Judge gave the jury acting in concert, and he read that, and that is a standard charge. It's acting with another with basically the same intent, and that's what they pretty easily found him guilty of. I mean, they weren't out for a long time. They asked for Pecker's testimony, who was their strongest witness, to corroborate Cohen's testimony, and obviously they did that. And here we are. As we speak, I'm assuming the judge is setting a sentencing date, which is typically about 6 weeks out, but nothing in this trial has been typical.
Right. And obviously Trump is going to appeal. So if he appeals, how does that affect the sentencing date?
The appeal will have no effect on the sentencing date. If you want to play out a crazy scenario, if the judge sentenced Donald Trump to a minute in jail, his lawyers can run to the appellate division and ask for what's called bail pending appeal, which is judges of the appellate division, which is uptown, please don't put him in jail, keep him out while we perfect the appeal. On an E-felony in this courthouse, someone with no criminal record whatsoever, there's typically no jail time.
Okay, one of our anchors, Bianca, has a question for you. Bianca, give it to me because he doesn't have IFB. What's your question?
Yeah, absolutely. We've talked to Arthur many times, especially in terms of this case, but one thing I found interesting from the jury instructions was that the judge pointed to specific pieces of evidence. Do judges normally do that in a case like this?
Okay, Bianca's question is, when the judge was reading his instructions to the jury yesterday, he actually made reference to certain pieces of evidence. Is that normal in cases for judges to do that during the instruction? Because what they're doing with the instruction is telling and teaching the jury how to apply the law correctly to the evidence in the charges.
Yes, judges, when they're basically giving a law school class to the jury, they are allowed to what's called marshal the evidence. They're not supposed to show any prejudice regarding that, but they're allowed to use examples from the evidence that's been legally admitted to give the jury an example of, and they're going to say, well, the prosecutor felt that, the defense is saying Michael Cohen lied. Well, here's the charge on credibility. And then he reads what jurors should take into consideration when they're judging the credibility of an individual.
Okay, now with Michael Cohen, too, the judge said you cannot convict Donald Trump just strictly on Michael Cohen's testimony because he is a convicted liar. Long history of lying. Lied before Congress, was disbarred, served time in prison for lying. So they couldn't do it just on Michael Cohen's testimony. So the fact that they asked for not just his testimony being reread, but also Pecker's testimony being reread from that meeting at Trump Tower in August of 2015, that pretty much says it all, don't you think?
As soon as I heard that the first note was Pecker, I knew what was going on in that jury room based on decades of being here. It's some jurors came in there and said, I'm not convinced beyond a reasonable doubt. And other jurors said, well, look, we'll convince you beyond a reasonable doubt. Let's hear what Pecker has to say, and we'll put it together with what Cohen said, and you'll see that they jive, and that's the evidence beyond a reasonable doubt. And obviously, those jurors who had doubts, those doubts were set aside by the readbacks of the testimony.
Okay, and of course, we keep mentioning David Pecker. He, of course, is the former head of the National Enquirer and a very longtime friend of Donald Trump. Steve, our anchor, has a question. Steve, you want to give it to me?
Yeah, sure. I was just curious, Arthur, obviously this is what he does for a living. Where does he think Trump's attorneys will focus on in their appeal of this verdict?
Yeah, Steve is asking, with all of your